Hello guys, and welcome to another episode of my lecture. On today's lecture, I will be discussing the Nigerian case of METALIMPEX versus AG LEVENTIS and Co. Nigeria Limited. Now, the fact of the case is that the appellant was METALIMPEX and they were owed 1.3 million by Wasco, with LEVENTIS, another company, as their guarantor. Now we have three companies here. We have METALIMPEX, who was owed by Wasco, and LEVENTIS, who was a guarantor of Wasco to METALIMPEX. So in the event where Wasco does not pay METALIMPEX the debt, LEVENTIS is supposed to pay those debts. The appellant was METALIMPEX and they were owed 1.3 million by Wasco, with LEVENTIS as their guarantor, who endorsed 12 bill of exchange to cover each of the 12 monthly installments of the appellant. These negotiations were done by a director of LEVENTIS. One of the bill, the second bill of exchange, was dishonored, so the appellant sued LEVENTIS as guarantor for dishonored bill. LEVENTIS denied liability, claiming that the director who signed the guarantee had no authority to commit the company as a guarantor or endorse the bills. The issue was whether the director who signed the guarantee on behalf of the company had the authority to commit the company. Now, this is where we have to look at the ostensible conduct, constructive notice, and the non-ostensible conduct, presumption of regularity. The ostensible conduct here can be gotten from the articles. The question we need to ask is that, does the articles or the memorandum, do they authorize a director to commit the company to stand as a guarantor? Do you understand? If such can be found in the articles, then we have constructive notice, we have ostensible conduct, and that is what a third party needs to see. The third party does not need to see whether or not the condition to doing that, maybe through a resolution or something, has been complied with. The third party doesn't need to see that. That's the non-ostensible conduct. That is the presumption of regularity, because the third party can presume that that would have been done. But let us look at the Supreme Court's judgment. The Supreme Court held that the appellant was entitled to assume that the director of the respondent company had authority to endorse the bill in the absence of any suspicious circumstance which would put the appellant on inquiry. It means that in this case the articles authorized it. So where the articles authorize the director to be able to commit a company, now whether or not the conditions to be met before the directors can do that has actually been met would not be an issue, since there is a presumption that such condition has been met. Do you understand? Let us look at what the Supreme Court stated again. Applying the rule in Tokant's case, it was sufficient for the appellants to satisfy themselves that the memorandum and articles of association of the defendant company, that the company was empowered to endorse bills of exchange, and its business could be conducted by directors who are also empowered to delegate their duties and powers to one or more of their members, and thereby come to the conclusion that a sole director have power to endorse the bill. Do you see? So when the court was, giving its judgment, it started first with the company is empowered to endorse bills of exchange. Number one. Number two, the business of the company to endorse bill of exchange is run by the word directors. That's number two. Number three, the directors are empowered to delegate their duty to one or more of their members. Therefore, there is a conclusion that a sole director might have the power to endorse the bill. Do you understand? What is important is that the power in fact exists. What is important is that there is an ostensible conduct. What is not important is that such conditions to be met before the exercise of that particular power can be done effectively has been done, because there is a presumption that such condition has been done. Do you understand? So I've explained using a lot of cases. In my next video, I will explain further using about 3 other Nigerian cases, and after that we go to the exceptions. So see you in my next class.